So next is about foreign LLP. So foreign LLP, what do you mean by foreign LLP? So we are seeing the part 2 of the video, part 1 is already done. So from foreign LLP means an LLP which is incorporated outside India but has a place of business in India. So that's basically a foreign LLP. What do you mean by foreign LLP? It is incorporated outside India but has a place of business in India. So like if it's incorporated outside India and has no Indian connection, that is if it does not have a place of business in India, then in that case it will not be considered under this act. I mean, we don't have to really be concerned about the regulations or the factors in here if at all it does not have any Indian connection, that is if it does not have a place of business in India. So basically foreign LLP is similar to a foreign company, which means it's incorporated outside India and has a place of business in India. Now what do you mean by LLP? LLP means an LLP, a partnership which is registered under this act. What do you mean by LLP agreements? We have partnership agreement. Similarly for LLP, we have LLP agreement, which is between partners or between LLP and the partners, which specifies their mutual rights and duties amongst themselves and in relation to the LLP. Who is a partner? Partner means any person who becomes a partner in LLP in accordance with the agreement, LLP agreement. What do you mean by small LLP? So small LLP is one wherein the contribution is up to 25 lakhs. So contribution is less than or equal to 25 lakh, and if turnover is less than or equal to 40 lakh. So contribution up to 25 lakh and turnover up to 40 lakh, then that would be referred to as small LLP. So what do you mean by contribution? It's basically capital contribution. Now what about this 5 crore and 50 crore? Now this means a limit that the government will specify in the future. Higher amount not exceeding 5 crore, over here not exceeding 50 crore. So government may increase this limit to up to 5 crore or 50 crore in the future, right? So currently this is 25 lakh and 40 lakh. And non-applicability of Indian Partnership Act 1932. So when is this act not applicable? See, this Indian Partnership Act, right? So Indian Partnership Act is not applicable to LLP because LLP has a specific act. So in that case, Indian Partnership Act will not be applicable to LLP. Partners mean any individual or body corporate can become a partner in LLP. Not just individual, body corporate also can become a partner in LLP. But if at all the individual is found to be of unsound mind or undischarged insolvent or is adjudicated as an insolvent. Undischarged insolvent meaning court has declared the person to be insolvent. Insolvent is one wherein liabilities exceed the amount of assets, wherein a person is not able to meet out his or her liabilities. Adjudicated to be insolvent. Applied to be adjudicated as insolvent means an application is made for court to adjudge him, that is to give a judgment that he is insolvent and that application is pending. Now in these cases, unsound mind or adjudicated insolvent, apply to be adjudicated as insolvent and application is pending, or undischarged insolvent. In these cases, an individual cannot become a partner in LLP. So minimum number of partners, similar to that of partnership firm, LLP should have at least 2 partners. So LLP should have at least 2 partners. And if at all, at any time, the number of partners is reduced below 2 and LLP carries on the business for more than 6 months, and so then that partner will be personally liable for obligations during that period. Let's take for example, there are only 2 partners in an LLP, A and B. B has left the LLP, now there's only A who's continuing this LLP's business for more than 6 months. He can continue up to 6 months, but if he's continuing with the number as 1, with the partner as 1, after 6 months, then he will be liable for personally liable. Generally, in case of LLP, there's no personal liability, but in this case, if at all he is carrying on the business as such for more than 6 months, then he is personally liable for all the obligations incurred during that period. What do you mean by designated partners? So designated partners. So what do you mean by designated partners? Designated partners mean partners who are designated under this act. So there has to be at least 2 designated partners, and one of them will have to be resident in India. So 2 designated partners, out of which one shall be resident and Indian resident. And what do you mean by Indian resident as per this act? As per this act, Indian resident means a person who has stayed for at least 120 days, more than or equal to 120 days during the preceding or during the current financial year only. Alright, so like take for example, if you have to determine the partnership status year for the financial year 23-24, then during the year a person should have stayed for at least 120 days, more than or equal to 120 days. Then in that case, the person is deemed to be resident of India, otherwise not. And then so here we have an example. So there has to be at least 2 designated partners, one of them will have to be resident of India. And suppose in case, see, in LLP, who can be partner? An individual can be partner, body corporate can also be partner. What if all the partners are body corporate? Now in that case, nominees of the body corporate can act as designated partners. What if all the partners are LLP, in an LLP? In that case, partners of that LLP can be designated partners over here. So generally designated partners, at least 2 will have to be there in a LLP, and out of them 1 will have to be resident, Indian resident. So we have an example over here. There's an LLP by name Indian Helicopters LLP. There are totally 5 partners: Mr. A, Mr. B, Miss C, Miss D, and Miss E. So Mr. A and Mr. B is non-resident. Miss C, D, and E is resident. At least 2 should be designated partners. 1 of them should be resident of India. Here in this case, Mr. A and Mr. B are designated. Then it will not serve the purpose. Why it will not serve the purpose? Because see, in this case there will have to be 2 designated partners. 1 of them will have to be resident in India. So here they don't resident in India. So in this case, Mr. A and Mr. B both are non-residents, so it does not serve the purpose. At least 1 out of Miss C, Miss D, or Miss E will have to be partner over here. Only then it will suffice the purpose. Up next, we will see about the characteristics of LLP. So what are the characteristics of LLP? As we know, what are the characteristics of LLP? It's a body corporate. We already know it's a body corporate. It's a separate legal entity. It has common seal, perpetual succession. It's an artificial legal person. It has a flexibility to devise its own structure using LLP agreement. There's no mutual agency as in case of partnership firm. It's limited liability. Regarding management of business, we'll look into this. Compromise arrangement, conversion into LLP, minimum and maximum number of partners. It's a business for profit only. There are only certain companies which are for not for profit, like Section 8 company or NPO, etc. Other than that, all of the companies are for profit only. All the forms of institutions like company or maybe partnership firm are for profit only. So let's look into investigation, e-filing of documents, and for an LLP. So LLP is a body corporate. As we already know, LLP is a body corporate. It is a separate legal entity. I think this is something that we already know. LLP is a body corporate. It has perpetual succession. Any change in partners will not affect the existence, rights, or liabilities of LLP. Perpetual succession. Perpetual succession means continual succession. So LLP will continue irrespective of change in the partners of LLP. Partners may die or may become insane or retire or become insolvent. Still, it has no impact on the existence of LLP. So it is capable of entering into contracts and holding property in its own name. Separate legal entity. So LLP is a separate legal entity and is liable to the full extent of assets, but liability of partners will be limited to the agreed contribution in LLP. Creditors of LLP will be creditors of LLP alone, not of separate legal entity, right? So LLP is different, partners are different. Unlike partnership form or sole proprietor concern, where the sole owner and the proprietary concern is one and the same, partners in the firm are one and the same. So LLP is like a company wherein it has separate legal entity. So LLP is different and partners are different. So creditors of LLP will be creditors of LLP alone, meaning they can claim their liabilities from the LLP's assets only, not from the personal assets of the partners. Partners will be liable only to the extent of their agreed contribution. LLP agreement. So LLP has an agreement wherein mutual rights and duties will be decided. There's a flexibility to devise agreement. Partners will have the right to devise a internal structure as per their requirement. They've got the flexibility to do so. Suppose if there's no formal agreement, now in that case, so if at all they don't have any formal agreement, in that case mutual rights and duties under the Act would be applicable. This is given under Schedule 1. Artificial legal person. Obviously LLP is an artificial legal person because it's created by a legal process and is clothed with all the rights of an individual. It's a person because it has got all the rights of an individual. It is artificial because it's legal because it's created by process of law. It's artificial because it's not created by a natural process such as birth. So it can do everything which a natural person can do, except that it cannot be sent to jail, cannot take an oath, cannot marry or get divorced, nor can it practice a learned profession like CEO medicine. So basically it has got all the rights of an individual. Like for example, it can hold, acquire or sell property in its name. It can enter into any contract. It can sue another person, any third party. Any third party can sue the LLP, or LLP can sue any other third party. But generally it cannot do certain activities which a human can do, which an individual can do. It's invisible, intangible, immortal. Immortal is because it can continue regardless of change in the members of LLP. it's intangible, and also it's invisible. It can be dissolved by law alone. It's not fictitious. It's not something that is bogus because it really exists. Next is about common seal. So common seal is nothing but an official signature. So just like humans, we have our own signatures. Similarly, if we have to authorize, authenticate any document, what do? We give a signature. We place a signature over there. Similarly, for LLP, since it's an artificial person, its official signature is common seal. So it's an artificial person can act through its partners and designated partners. May decide to have a common seal. Again, having a common seal for LLP is not mandatory at all. If at all they do not have common seal, then in the place of common seal, at least 2 designated partners will have to sign. That's all. And if at all it has common seal, then it will have to be kept under the custody of a responsible official, and it has to be affixed in presence of 2 designated partners. Limited liability. So obviously, as we know, LLP has limited liability. LLP's liability, partner's liability is limited only to the extent of their agreed contribution, not beyond that. That contribution can be tangible and intangible, but their liability is only to the extent of agreed contribution, not beyond that. Like professionals like engineering consultants, legal advisors, accounting professionals are afraid of entering into business due to unlimited liability. Hence, the LLP Partnership Act provides an avenue for these professionals to limited liability partnership firms, which restricts their liability to agreed amount. This has encouraged professionals to form LLP. Because again, they'll be afraid to enter into any business or to set up a firm because of unlimited liability. But if they can cooperate with LLP, then they can get the benefit of limited liability at the same time with lower cost. Unlike a company wherein they'll have to spend huge amounts for statutory and other legal requirements. Management of business, so it will be managed by partners, but for legal compliances, only designated partners are responsible. Minimum and maximum. Minimum, there will have to be at least 2. Maximum, there's no limit. Maximum, unlimited. So the minimum, there will have to be at least 2 partners and at least 2 designated partners, and it's a business for profit only. So basically, you can form LLP for profit only. You cannot form LLP for charitable or non-economic purposes. It cannot be formed for that purpose. Investigation. Central government shall have the powers to investigate the affairs of an LLP or by appointing a competent authority. Compromise arrangement. So if at all LLP is getting merged or is getting amalgamated, then they will have to follow the provisions of LLP Act of 2008. Conversion into LLP. If at all they are converting a firm or private company or unlisted public company into LLP, then they will have to follow the provisions of LLP Act of 2008. So conversion of firm into LLP is given under Schedule 2, and private company into LLP is given under Schedule 3. Unlisted public company into LLP is given under Schedule 4. In that case, I will have to comply with these provisions of the LLP Act. E-filing of documents. So nowadays, we do not have the physical filing of documents. It will be only e-filing of documents. So right from incorporation to filing their annual return or maybe other documents which are required under the Act, they will have to go with e-filing of documents. In the MCA portal, that is www.mca.gov.in, they will have to, for example, if they are filing an annual return, now in that case they will have to fill out all the details, name the company, other details, the financial details and everything, and then it has to be signed. And now this is not something which has to be physically signed with pen and paper. Since this is an electronic document, it has to be signed by way of electronic or digital signature. Digital signature, like take for example we have DSC, which is digital signature certificate, through which they can attach a digital signature over here. Fill out the form and then attach the digital signature of whom? Of the designated partners by use of electronic or digital signature, and then they will have to upload in this portal in the form of computer readable electronic form. In that format they will have to upload. Foreign LLP, as we already saw, is nothing but an LLP which is incorporated outside India but has a place of business in India. Foreign LLP can become a partner in an Indian LLP. So there's one more thing that has to be seen, whether foreign LLP can become a partner in Indian LLP. For sure, they can become a partner in Indian LLP. Individual can become partner in LLP. And not just that, any other body corporate can also become partner in Indian LLP. Firms can become partner in Indian LLP. Foreign LLPs can also become partner in Indian LLP. What are the advantages of LLP form? So as we know, LLP form advantages are that it's simple to form. That's one thing, and it has limited liability, and it has got flexible capital structure. It's easy to form, easy to dissolve, and there are not much detailed legal and procedural requirements like in case of company. So there are only limited procedures. At the same time, they enjoy limited liability, and also they've got the flexibility to operate. So these are the two main things that we saw. It's easy to form, it's easy to resolve. It has got flexibility to devise your internal structure on the basis of LLP agreement, like in case of partnership. They have limited liability benefit as well. So it operates on the basis of agreement, flexibility without imposing any detailed legal and procedural requirements. It's easy to form, easy to resolve, limited liability and flexible capital structure. So these are the benefits of LLP. So up next we'll have to see about few more things, which includes incorporation till the differences, which we will look into in part 3 of the video. Thank you. So this is again a very easy chapter that can be read. Please do not omit any of the chapters throughout, and let's revise each of them. Thank you.